Thank you, folks. I'm going to now pass the baton to Mr. Jacob. Thank you.
Before I get into the heart of this, I want to say that I am former law enforcement. I was a police officer, defended law enforcement for 10 years. I was a deputy attorney general in Pennsylvania for a couple of years, and now for the last 5 years, I've been doing civil rights litigation on the plaintiff's side, and the last 3 nationally. So I've been all over these cases. I've been on the street as a police officer. I feel for the Decker family as to what happened on the night in question, and so does Ryan Larson. It's never easy when an officer is hurt, certainly never easy when an officer is murdered, serving the citizens. And Officer Decker's family, I'm sure, is hurting and will always hurt for the rest of their lives. And the family deserves closure, as does the community, along with Mr. Larson. But because of the theory that's been put out there, that this case must remain open, there's been no closure. The case has remained open, stringing the family along of the police officer who died, leading them to believe that there's still a chapter that is yet to be written. And we know that's not true. And the reason the investigation remains open is pretty clear. And that's because it can be. It can be because there's no statute of limitations for the crime of murder. Therefore, it's allowed to be left open. And if it's left open, nothing gets released to the public. It's that simple. It is an effort to not be transparent about what happened on a night in a small town, 4,000 people, when an officer was murdered. And what we know happened from just the little evidence that has trickled out publicly is that investigators absolutely and completely botched this investigation. They targeted on the wrong individual, Mr. Larson, who we know definitively was not involved in this crime. And now they don't want it to come out what they did, because if it comes out what happened, then people start losing jobs, people start losing political careers, and obviously self-interest prevails. But I think it's time, after all this time, that self-interest be put aside and the taxpayers frankly realize that what has happened is not only a travesty to the officer's family and to the community, but it's going to cost a lot of money now to make Mr. Larson whole, Mr. Rassier whole. And if the municipalities choose to defend these cases for which there is no defense, it's going to cost significantly more. There comes a time when we just need to cut our losses and realize that people have been wronged and harmed and make things right and move on. And yes, there are certain people who were involved in this case, in Mr. Larson's case, and presumably in Mr. Rassier's case, who should never have had the jobs that they had, who were not trained to do the jobs that they were asked to do, and should not be continuing in their capacities as serving the public, because they're not serving the public, they're serving themselves. It has been reported that on the night in question, Officer Ryder was asked to check on the welfare of Mr. Larson. Now, he was referred to as suicidal on the night in question, but in actuality, there was no evidence indicating that he was suicidal. He had made comments, purportedly, in the past that had concerned family, and family had asked that officers go check on the welfare simply because they could not get in touch with him that night. And they couldn't get in touch with him because he had turned his phone off and had gone to sleep. Many of us have done that. But from that fact, we heard about a suicidal individual and Mr. Larson's been painted as this horrible person that needed to be checked on that night, was very dangerous, when in fact, he was a guy who went home, turned off his phone, and went to sleep. And a concerned mother reached out and said, "Could you check on my child?" Mr. Larson was fine that night. Mr. Larson was sleeping that night. I spoke to an eyewitness who says that at 6 o'clock and still at 9 o'clock, Mr. Larson's vehicle was sitting where it was sitting the entire time in the parking lot to the rear of Winter's Sports Bar and Grill. The vehicle never moved, so where it was reported that it wasn't there when Officer Ryder arrived is curious, to say the least, because again, an eyewitness puts it there. 2 eyewitnesses actually put it there. Officer Ryder claims that when Officer Decker exited his vehicle and began to walk towards Mr. Larson's apartment, that's when the shooting occurred. And it's my understanding that despite having called a backup police officer down to the scene, that Officer Ryder remained in his vehicle. And that once the shooting occurred, Officer Ryder did not get out and pursue the suspect, who he claimed had proceeded away from the scene, away from the building where Mr. Larson was sleeping. He didn't pursue him, and in fact, he fled the location. And he fled the location while Officer Decker was lying on the ground dying. Mr. Larson was still home sleeping. He didn't know any of this was going on. But for some reason, suspicion turned to Mr. Larson, which is very curious considering 2 independent eyewitnesses, Officer Ryder being one and a citizen being another, reported that the suspect was seen leaving the scene shortly after the shooting. Officer Ryder himself reported the suspect leaving the scene on foot, and the citizen reported seeing a loud, dark-colored van leaving the area as well. Now, there's a time difference between the 2 reports, which certainly, based on the location that they put both the van and the suspect, makes it appear that it's one and the same. So all indications when officers were arriving to investigate the shooting was that a shooting had occurred coincidentally in the location where there had been a call prior, several hours before in the evening, and that the suspect had fled the area. But with that information, somehow, for some reason, the focus became Mr. Larson. And of course I asked, why? Nobody's ever answered the question, why are you focused on Mr. Larson? And if you think about it, it's a really good question. You literally have nothing other than the mere coincidence that several hours earlier, there had been a mother who asked to check on her child at a property, and several hours later, an officer is killed by somebody leaving the scene. But Mr. Larson, who's sleeping in his apartment, is now the prime suspect. CERT team surrounded the property. Mr. Larson's inside sleeping. CERT team decided to force their way into Mr. Larson's apartment. Mr. Larson sleeping. Now this is very important. This is a very important point because the Fourth Amendment to the Constitution says that in order to enter someone's home, you need a warrant, or you need consent, or you need probable cause and exigent circumstances. Warrant, consent, or probable cause and exigent circumstances. Not only did they not have probable cause connecting Mr. Larson to this horrible crime, but they didn't have exigent circumstances either. If you think about it, tragically, Officer Decker was now deceased. The property's completely surrounded. There is no exigency requiring them to go through that door with rifles and wake Mr. Larson and pull him from his bed. So, just looking at it from that standpoint, Mr. Larson's federal civil rights were violated as soon as the officers went through that door. And it's not a defense that they were following an unlawful order. You don't get to say, well, my boss told me to do so. Once they're inside, there's another requirement, and that's that there be probable cause to arrest. So crossing the threshold is one issue. But just because you're standing there doesn't mean you get to arrest everybody inside. The Fourth Amendment says that you must have probable cause that the person that you're arresting committed a crime. And the question is, well, what does probable cause mean? Well, it's actually a relatively easy definition, in that it's one, that probably a crime occurred, and two, that the person that you're arresting probably committed that crime. I think we've already gone over the fact that there is zero evidence linking this crime to Mr. Larson at that point in time and subsequently. So they unlawfully enter his apartment with rifles pointed at him, and then they take him into custody unlawfully for a crime that he didn't commit. There was not even reasonable suspicion, let alone probable cause, at that time that Mr. Larson was involved. Subsequently, Mr. Larson was taken from his property. He was told, we're not going to tell you why we're taking you. The CERT team reported to the incident commander, to my understanding through my sources, that they had made numerous entries into numerous properties, but they were pretty certain that Mr. Larson was not faking, that he was in fact asleep when they came through that door. And he asked, why am I in handcuffs? What is going on? Truly having no idea what was going on, and was not told. They said, we'll tell you when you get you downtown. He's shirtless. He's paraded out of his apartment in handcuffs in the middle of the night. He's taken downtown, and he is interrogated by Captain Pam Jensen and Investigator Kenneth McDonald. Names ring a bell? He's interrogated for almost 6 hours, shown pictures of Officer Decker's injuries in the body, and asked, why did you do it? He had to ask him, before they showed him the pictures, do what? Because he didn't even know why he was sitting there. Could you imagine? This could be anybody in this room. This could be anybody's child in this room. This could be anybody's family member. This was, let's pin it on the neighbor. Sound familiar? This could literally be anybody in this room who is yanked out of their bed and told you just killed a police officer. 6 hours. He had to look at these pictures and be told he should cooperate, be told he should just be a man and admit what he did. That works on you, especially when you have family, when you have a mother, father, when you have siblings who you know are hearing about this, who you can't speak to. When you have a son, and you know he's going to hear about this. When you have friends who know you were just ripped out of your bed and out of the apartment accused of killing a police officer when there's only 4,000 in a town, word gets around pretty quick. He's given a smock, and he's strip searched. And he's told, you can wear that smock because you're suicidal. And he's put in a small cell, alone, for 5 days. The window's blocked over, no sunlight. 1 hour a day he gets to come out. He's called Cop Killer. He was given a phone book to read as a joke because he's a cop killer for entertainment. He was not treated well while he was in there. And this is the part of the story that nobody really thought to think about what was happening to him. He got to make one phone call a day. And so, of course, he used them carefully. He called Mom, of course, first. And then he calls Dad. Then he called the media. And that's because he wanted help. And you guys did give him help. You got his story out there, and he appreciates that. And you've been looking into his story, and Mr. Larson really appreciates that as well. You've really done your homework in this case. You've really done your homework in the Wetterland case, Mr. Rassier's case. It's been noticed. It doesn't always happen. And it's commendable. We're doing an important job here trying to litigate these cases once they're filed and investigating, making sure we do our due diligence before they're filed. But the media plays a huge, huge important role in our society. So it's my little speech to the aside in that regard. There was an affidavit that was filed. It's called an application for judicial determination of probable cause to detain. That's a mouthful there. It was filed by a Sergeant Timothy J. Dismarius. I could be pronouncing his name wrong, and I apologize to him. And Deputy Stephen P. Lemkuhl, and I could be Lemkuhl. We go back and forth on the pronunciation, so I apologize as well. The affidavit is signed by both officers. That affidavit is a sworn affidavit that is sent along with the application in order to detain, once the person's arrested, to detain him for a longer period of time. Now, normally when there's been a warrant or something, a document of this nature, and the judge signs off on it, normally that insulates police officers from liability. And when a district attorney signs off on it, as in this case occurred, again, normally that insulates the officers from liability. But there's an exception, and that's when there's been false or misleading statements that have been placed in the affidavit of probable cause, or when there's been material pieces of information excluded from the affidavit of probable cause. The question that the courts will look at is, would a independent, neutral judicial officer want to know the information, the correct information, or the missing information in determining whether or not there's probable cause and making that determination? And if, through the manner in which the affidavit is drafted, it's interfered with the discretion of the district attorney or of the court, it no longer insulates the individuals from liability. And this affidavit is very troubling, frankly, when you read it. And I think just from what I told you today, you can already tell why. The affidavit states that for officer safety, Mr. Larson was asked, "Where's the gun?" when the officers came through the door. Now, as a former police officer, I know why those words were in there. It's not by mistake. Officer safety would be an exception to needing to read somebody their rights during the course of an investigation. You can ask for officer safety, where's the bomb, where's the gun, where's whatever. So they were going for what they thought was a murder weapon, or attempting to go for a dangerous weapon, a key piece of evidence, but not wanting to read the rights to Mr. Larson. When you put that in the document, and when it says that Mr. Larson told them it's under my pillow, the implication is, where's the gun? It's under my pillow, that we're talking about the murder weapon. That's very misleading, and that's not how an affidavit of probable cause is supposed to be written. The affidavit fails to indicate that 2 shotgun shells were found at the scene on the night in question, and that the wounds were consistent with having been shot with a shotgun. That's very material information that a judicial officer would want to know, especially considering there were no shotguns located in Mr. Larson's property, a fact which was not included in the affidavit of probable cause. The affidavit provides that there was a hooded sweatshirt located in Mr. Larson's bedroom that matched the description provided by Officer Ryder. There's no indication that Officer Ryder ever looked at the sweatshirt and confirmed it, and there's no description of the sweatshirt and no description of what the description was that Officer Ryder purportedly provided to law enforcement. A dark sweatshirt with a hood is hardly a description. And interestingly, and this was a piece that was just discovered last night, as we continue to peruse and go over the evidence, things continue to jump out at you. You'll actually hear the 911 dispatcher on the radio communications put out over the radio that there's no description, no clothing description. Yet somehow they came up with a clothing description and had it in the affidavit of probable cause. The affidavit fails to mention that Mr. Larson's hands were swabbed for gunshot residue. I would think if I was a judge and I was evaluating whether or not there's probable cause, I'd want to know that you swabbed the individual's hands, and I'd want to know what that test said. Not only did they not tell him, but they didn't tell him that the test was negative. And the affidavit does not discuss the fact that Officer Ryder, there's a question about whether he timely reported the shooting, but did not pursue the suspect, did not render medical aid to Officer Decker, and fled the location. Now, if I was looking at this information and evaluating whether this individual should be held with literally no evidence, I'd want to know that there was another individual, a police officer, who was acting in a way that police officers don't act. As a former police officer, I can say that you're not trained. It's not pursuant to training and policy or training procedure to not pursue a suspect, to flee a shooting scene, and to not render medical care. So the fact that an individual has deviated from what is accepted standard practices and policies is certainly questionable. If anything, on the night in question, right after the shooting, there was evidence that pointed to Officer Ryder being involved in this, and I'm not saying he was, but just understand, on balance, there was evidence that at least put Officer Ryder under reasonable suspicion, and there was nothing, literally nothing, that pointed to Mr. Larson. While Mr. Larson was being held, that was not all that was happening to him. The officers decided to go into his home, put holes in his walls, put holes in his floor, looking for stuff. They destroyed personal property. They took personal property. And to this day, this happened in 2012, to this day, Mr. Larson's property has not been returned. Stearns County actually went into court when Mr. Larson tried to get his property back a few years after, and initially the judge said, you need to return the property, and Stearns County asked to have what we call an in-camera review. It's a closed door with the judge, and within seconds came out, and after telling the judge something, suddenly the property could continue to be held. Well, it's time we tell Mr. Larson what it was that was said in camera that convinced a judge to continue to hold his property until today. And in that regard, yesterday, I served the Stearns County Attorney's Office with a written demand that they return Mr. Larson's property immediately or provide me with a written explanation as to why they refused to do so. Because that determination was made, I believe, in 2013. So it's now been another three and a half years as to whatever it is that they continue to investigate involving Mr. Larson. Mr. Larson was let out after 5 days, and that's when the court realized there is literally not a shred of evidence to link Mr. Larson to this crime. Cold Spring is a small community, like I said, 4,000. Actually, I think technically the sign says 4,025. I don't want to misrepresent facts. Well, naturally, Mr. Larson, who had been living there for a long time, did not feel very comfortable walking around in the community when he was reading online death threats that were coming to him. Build a gallows. Get the lynch mob ready. I'll supply the rope. Put a full magazine in him. When the police chief reports that Mr. Larson should not come into town to get clothing, he needs an escort because he's not safe. That's no way to live, and that's no way an innocent person should have to live in their own community. Prior to his arrest, Mr. Larson was studying machine tool technology at St. Cloud Community College. He was doing well. He ended up pretty much failing out for a period of time. I'm happy to report that while 2 years late, he's now completed the degree. But it put a pause on his career for 2 years, and frankly, it's ended his career. Because now, in the age of the internet, in the age of social media, our reputations live on forever. Whatever happens to you, it's online, and it stays online. It stays online forever. What's the first thing an employer does? So you're all laughing. It's because you do it too. When you're going to do a story, you run them in the internet. You Google the name. Well, guess what comes up about Mr. Larson? He's a suspect in an ongoing investigation of a police murder.
Pitiful.
Can't get a job. Now he's forced, for the last 4 or almost 5 years, to work odd jobs so he can feed himself. Then he can't pursue the career that he's been studying. On August 6, 2013, the Minnesota Department of Public Safety issued a press release. I'm sure you all have looked at the press release, but there were a couple important things stated in that release. One is that the investigators had compiled evidence that would have resulted in Eric Joseph Thomas, I believe is how he pronounces his name, being arrested for the murder of Officer Tom Decker, had Mr. Thomas not taken his own life on January 2nd, 2013. We know the tragic story. I have since received some information as to how and why Mr. Thomas was likely down there that night. Not clear that with my sources, I'm allowed to disclose all that yet. But it brought some clarity to this, but I know it's information that law enforcement knows, which makes it even more apparent that Mr. Larson, the focus should never have been on him. What's interesting is the press release also stated that the investigation has provided no information, not some information. The words "no information" were in the press release. That Mr. Larson participated in Officer Decker's murder. There is no known connection, they said, no known connection between Mr. Thomas and Mr. Larson related to this crime. And yet, it was put in the press release then discussions with the Stearns County attorney. The BCA and Stearns County Sheriff's Office have been advised to leave the case open. Leave the case open. Almost 4 years has passed since that press release. The investigation is still open. Officer Decker's family deserves closure. They deserve to know the end of the story. They deserve to know that it really is over. That the individual who killed Officer Decker is deceased as well. And that Mr. Larson was wrongfully charged. And that it's the end. And yes, if there was wrongdoing committed by investigators, which we know there was, from the misstatements and the lack of truthfulness in the affidavit of probable cause, and the violations of civil rights, just entering Mr. Larson's apartment to begin with that night, it's time to close the chapter and just make things as right as they can be. I have called on, I said in writing, and I guess I do it again, to Stearns County to do the right thing here. Mr. Larson's hurting, and I don't blame him. I mean, just to get him to come here and sit in front of all of you is difficult for him to do, because a lot of people still look at him as the cop killer and as somebody who eventually there's going to be a piece of information that comes out, because that's the way Stearns County has portrayed him, as a continuing person of interest. So I appreciate your reporting on this important story. Mr. Larson appreciates your reporting on this story. If you have any other questions, you have my contact information. I'm with Jacob Litigation. It's a national law firm. It's on the internet, jacoblitigation.com. You can find me there. But I also gave my cell phone to a few people. I'd be willing to keep in touch with anybody, because, again, like Mr. Pat, or Attorney Patty, pardon me, I believe in keeping a good relationship with the media. You guys are a vital part of protecting citizens' rights, and the citizens deserve better here, and it's because of a lot of you, and a small part because of us, that we're headed in the right direction in that regard.
Thank you, Mr. Jacob. Mr. Rogers, could you give the contact information for tips, if you'd be kind enough, please?
Yeah, my agency can be reached at tips at rstevenrogers.com. That's rstevenrogers.com. I will be handling the input of tips and evidence and then forwarding them to Mr. Patton as necessary.
These cases will be litigated separately. They have to be. They're both Mr. Larson and Mr. Grassier. I hope I'm pronouncing that correctly. I apologize. But naturally, they can be witnesses in each other's cases. We think it's important that each case be litigated completely separately. So tips for the Waterline case should go to Mr. Patton and to the detective at the end of the table. Tips for Mr. Larson's or any information you can help provide or something that I'm overlooking or just anything at all, however slight, should come my way. Thank you.
Yeah, thank you.